So I wanted to welcome everyone tonight. We are doing the worst fears that you might have or might have encountered in your child custody battles. So we are here tonight to talk about your worst fears in child custody battles. I would imagine that every single one of us has gone through some kind of fear that wasn't one that we expected when we got involved in trying to protect our rights and our children's rights. And I think one of the primary ones for me was that I didn't expect to be getting attacked by my own attorneys. I also didn't expect that other people were going to take over the rights to my child or my children and start telling me what to do. And I didn't even think that it mattered if they tried. I didn't expect a judge to actually entertain those things. So there were a lot of things that happened that caused me to develop fears that I didn't originally even have in the process. And one of these that created this fear is what they call the best interest doctrine. So we're going to go over that a little bit tonight. And I'm Sherry Palmer. I'm your host along with Ron Palmer. We're with Fixed Family Courts. You can contact us there anytime at fixedfamilycourts.com. We're also authors and strategists. We also help coach attorneys and parents one-on-one to help teach them how to use their constitutional arguments, even in the face of judges that try to tell you that they don't have holding in their court. That is incorrect. And if you have any questions about that, contact us and we'll tell you why. So if you're in the beginning of this process, you may have asked, where do I start? How much money will I need? How long does it take? What kind of help do I need? And where do I find help? We simplify this process for you. No matter where you are in it, even if you're not in the beginning, where you start is always, always, always with your rights, because that is what empowers you. There are lots of people out there that are going to argue with you and say, your children have rights and somebody needs to protect those. And when you're arguing with the other parent, now somebody has to take over because you're not protecting the child's rights because all you're doing is thinking about yourself. What do they tell you when you're on an airplane? They tell you to put your mask on first if you have children. And why do they tell you that? Because if you don't take care of yourself, you won't be there to help them. And isn't that what's been happening in these court cases? Is when you didn't protect your rights, you're no longer there with your child, for your child, and it's not usually by choice. It's usually because somebody else took it from you. So if you're not going to protect your rights, they're going to give someone else power, aren't they? A lot of times it's the ex, a lot of times it's a parent facilitator or somebody else. So all of this goes back to creating fear. It creates fear in you that now all of a sudden you've lost control. And so what do you start doing? You start spending money. You start looking at who can help you get that power and control back. And I think the first people you look at are attorneys. You think the attorneys are there to protect your ability to do that. But what happens is you go to them as a victim. You go to them and you say, oh my God, everything's out of control, please help me. And they're like, well, how much are you willing to pay? And then they're like, how much do you have? How much is your house worth? And you wonder why they're saying these things. Because you're asking them to come in there and save you from something. But you're not asking them, hey, are you going to protect my rights? What empowers me? Or any of that. So you don't have it straight in your own mind. And they don't have time or the money to educate you on that stuff, do they? Because they're handling a lot of cases. I'm not making excuses for attorneys. I'm just kind of telling you the reality is that if you don't know what your rights are, there aren't many people that are going to care. You know, it's no different than when a police officer pulls you over. If you don't know that it's your right to decline having them search your car or letting them into your business, then they'll come into your business. Now, of course, we have Miranda rights in criminal law, but that's because criminals, appealed. They pushed the issue. They said, we must have rights. We want them protected. Well, that's the position parents are in, right? So how long will this take? Well, some of that is up to all of you. One is, if you buy into the patterns that they've been using, it might take a long time because they're going to want a bunch of studies and do a bunch of other stuff. And I'm not going to take a lot of time on that because we cover that in other webinars. We're going to get into some other stuff tonight. What we're going to show you tonight is going to help you shorten this process. And it's exactly what we've been saying to do. So that gets to what kind of help do I need? That's what we're going to go over tonight. We're going to show you that the constitutional arguments that we wrote in our book do work. That case from Michigan uses the arguments that we've written about. So where do I find help? You find it by talking to people that know your constitutional rights, people that know the process and how to insert them into it. You don't find help from other people that are working in the process and using the same patterns that they've been using for generations that are hurting families. And so those would be generally the mediators, the gals, the attorneys. So pretty much most of the people that work in the process, work in the system, are using the same process and procedures that they've been told must be used. So if you want to challenge that, they're probably not the right ones to do that with. That could threaten what they consider their status quo, right? And a lot of you know, you've talked about they make money and they do all these things, but the way I look at this is not so much arguing that do they or don't they make money, because everybody makes money doing something, but it's are they or aren't they doing the job that you expected to be done? So the fear that you've developed in all of this is because you're not getting the help that you need, you're running out of money, and what happens when you run out of money? You can't fight to be with your children anymore, and some of you have gone a very long time without seeing your children. So once you've embarked on this journey, what do you need to know? The first thing you should know, you look to Stanley, and you say the Constitution does not permit the state to presume rather than prove a parent's unfitness, solely because it's more convenient to presume than to prove. So what's happening with most of you is you're going in, you have these what they call hearings, and they turn around and use low standards of proof and decide, sometimes it's just attorneys in the room, the parents don't even get to go in, and the judge decides one of you gets their rights deprived. One of you doesn't get to see the children as much. One of you gets to pay for the majority of this, right? Well, a lot of that is because you didn't have an attorney or yourself argue that that's not permitted. And this case in Ree Sanders that we're going to look over in a minute says exactly that. It may be a Michigan Supreme Court case, but you guys can take the wording right out of it. You can tell your judge, look, these are Supreme Court justices from another state. I understand it's not controlling. But this is not just argument made by them. They took a lot of the argument from the Supreme Court of the United States. And like I said, we've written these arguments in our books, and now you know they work. And they're talking about fundamental things, not things that just all of a sudden were given to us. These are not new rights. So you can ask your judge to consider using them, and if that judge doesn't, use the same procedure that this father in this case did. He used an interlocutory argument. He actually challenged based on before his case was final, which is super, super important because a lot of you are getting stuck in the process. I don't know if this particular parent's here, but one of them is they keep having what they call status hearings or status conferences. And all they do in those is decide what's in the best interest of the child, right? And the parent keeps trying to argue, I decide best interest. What happened is the state cut that step out. They cut the step out where they were supposed to prove the fitness of the parent before they started deciding best interest for the child. So because they cut that step out, that parent now needs to go to the appellate court and argue that that step was skipped and look at, you know, the rest of the rules in their state and put together a solid argument to challenge that court's using jurisdiction over them without the proper due process. And you'll understand it more, again, if you read in Reese Sanders. So all of these things that they order in these hearings that most of you are going through, psych evals, family studies, restrictions on your time with your child based on waiting for the results of the psych evals and the family studies and social studies, anything else, based on a facilitator's decision. So they are not using proper due process. But here's the other issue. If you don't demand a fitness hearing, then they can get away with this. Because there's other people that tried to challenge this very same thing that this father did in Michigan, and they didn't get hurt. Do you know why they didn't get hurt? Well, this court says why. And in fact, I'm going to go to that case real quick because I want to show you guys.
And when you're demanding a fitness hearing, you're not actually demanding a hearing. You're demanding that they not take any action to deprive you of any of your fundamental rights without first holding a hearing. Don't take that to mean you should demand and schedule a hearing. Force it upon them. It's their job to take the effort to prove you unfit. And what you need to say is, you cannot deprive me of fundamental rights without first proving me unfit.
Right. So first of all, recognize that if you're getting stuck in status hearings, status conferences, judge keeps saying, I want to wait for the next study, I want to wait because they just made another claim, then you need to push for that adjudication hearing.
So the deal is, when they make these temporary orders, their clock is ticking, and they have to prove you unfit within a certain amount of time, or they have to return your child to you. And that's what you need to put before them. Due process demands that if you believe there is probable cause to think that I'm harming my child or that I'm unfit, that you prove that in a reasonable amount of time, and if you fail to prove it, you must return my child to me.
Okay, and here's let me go back real quick, because I said, why did Mays, it's a case called In Re Mays, and we're looking at Sanders, by the way, and if you notice, we're using scholar.google.com, to where you can find all these cases.
And real quick, when you see in re, what it means is that it wasn't a traditional appeal, it was a mandamus or a habeas petition. And these are just different ways to get into the court, into the appellate court, based on different criteria.
And this mandamus or mandamus, as some people call it, this was off of an interlocutory order, which was temporary orders. He was in status hearings. So that's why I'm telling all of you that are here tonight, this is beautiful news, because we were all struggling with, how do we get heard during the time that the court is saying, I didn't make a final order, so it's not right for appeal. So they kept getting away with limiting your rights, your time, depriving you, putting burdens on you without meeting the due process standards, and you had nowhere to go. And we knew that there was mandamus and things like that, but we hadn't seen anyone use it successfully yet. And
keep in mind, the rules when it comes to interlocutory appeals is they're different in each state. And interlocutory simply means that your orders are not final. These are non-final orders you're appealing. And usually you have to appeal these orders through a mandamus proceeding. If you happen to be in jail through contempt or whatever other mechanism, then you would typically need to file a habeas petition.
And I want to remind everyone, Ron and I are not attorneys. We're constitutional scholars. We do research, and then we try to simplify cases that we read and show you what we believe would be the interpretation, which is totally under your First Amendment right to interpret what your beliefs are and how you understand these interpretations. You can share this with anyone if you do it yourself as well. As long as you are not practicing law, you are not trying to do pleadings for someone else, and you're not trying to represent them. So just...
And that's a very technical legal argument, so don't take that as saying we're telling you you're able to do something. The First Amendment allows you to communicate political ideas. It allows you to associate or to petition the government. And when you file pleadings, you are petitioning the government. The judicial branch is a branch of government. So, but they jealously guard their monopoly in this area, and they like to punish people for doing these things. So be very, very careful if you go about helping people or writing things up for people. That's not what we're telling you to do.
Okay, and how are we doing, Tommy? Can you all still hear us?
Oh, yes, I can hear you. I can see you. But I'm absolutely confused that I personally have been doing this for 7 years.
Mm-hmm.
And I don't understand how I didn't know what Ron was just talking about. Why is it a secret that I don't have the right to say, prove me to be unfit, and then we can have this conversation?
Because
I never.
they confuse everything in family law. They say, oh, what about the children? Oh my God, we have to save the children, the children, the children. And what they do is they use that to go about destroying families. And they've been doing it, they were doing it before the 14th Amendment was passed, and they've never adjusted what they've done based on the 14th Amendment. And one of the things, that's basically what we're attempting to do, is force the courts to recognize the 14th Amendment in family law and to abide by it.
And that's what I'm going to show you here, Tommy, because remember, this ruling that we're showing you right now, it's brand new. It just happened 2014.
That's a state court now, so anybody in Michigan, this is controlling for you. Outside of Michigan, you can just use it as reference for the logic and the legal thinking.
But what we're telling you is these arguments that this attorney used in this case are the same arguments we make in our book. So that's why we're saying these arguments work.
And so what this does for you is when you go before a judge or you speak to another attorney, the opposing attorney, and they say, oh, you're full of it, you don't know what you're talking about. You pull out the case. With the Supreme Court of Michigan says exactly the same thing I'm saying, so I can't be that full of it if one of the Supreme Courts of a state says the exact same thing.
And then you would say, and by the way, they reference, let me go up to they reference Stanley, they reference Troxel, they reference
Eldridge.
Yeah, Eldridge test. We have all of those in our book, so we explain them a little more than what they do in this, because as you see this, their explanation for this case basically ends, let me see if I can find it. It's not a very long opinion. It's the dissenter that wrote a long opinion after. Okay, this opinion ends right here. Okay, and if you look on the right side, you'll see that that's not very far down. This opinion goes all the way down to here, and then they have, their citations and references. What that means, dissenting, by the way, is this justice disagreed with something, and in fact, he agreed with a lot of stuff, but what he disagreed with was the fact that they were saying that these statutes that they were using were unconstitutional. He wanted to argue that it's, for 70 years they've been using them, and this Judge Markman is on the side of, now you just made it more difficult for courts to protect children and parents and to take jurisdiction over the child. But
I don't know how many of you are old enough to remember, but I'm a child of the 70s, and Miranda came about in either the late 60s or early 70s. And everybody and their brother were up in arms about how much crime we would have because Miranda would be letting criminals go because some cop made a technical error, and at least one or more of the Dirty Harry movies played on that concept. But we found over the decades since then that that simply isn't the case, that was a bunch of hot air. It's very doable for the police to read people their rights and then to convict criminals of crimes. They simply have to follow the rules, and that's all we're saying about family court. You have to follow the rules. It's that simple.
And they say that in this case. They say that in the most recent case that they made a ruling on in the U.S. Supreme Court about the buffer zones on the East Coast. They just ruled the buffer zones. They couldn't use those. And they said, we understand that some of these rulings make it more expensive for the state. Like, let me give you a better example. Some of you might be not familiar with that, but you're probably familiar with, they just made a ruling saying that they had to get a warrant to search your phones. And they said, we understand this might make it more difficult to prosecute a criminal, because they prosecuted a guy whose phone they went through of a pretty heinous crime. I think it was a shooting or something. They prosecuted him because they found pictures or something in his phone. And so they said, we understand that this might make it more difficult. But what this does is this protects people from erroneous judgments. And in fact, that's in here. And I'll get back to Mays. But if you look up erroneous, you notice I use Control F to search cases. It protects people from the risk of error. Okay, and I'm going to go up to the first one because that's not where I want to be. And there's a standard that they use, and it depends on what rights that you're talking about as to how much protection they want to give somebody against risk of error. And as an example, and we use this example in the classes that we teach, is if you're talking about a money dispute, they may use a lower standard of proof because the risk of error people don't care about quite as much because it's not a life, it's not something that's life-altering like maybe the death penalty. It's also not as life-altering as taking away one of your liberties, like your time with your child. So they lower that standard and they allow for, lower proof, preponderance of evidence, things like that in those cases about money. When it comes to criminal stuff, they raise the standard because there's more at risk. Okay, so let's go back to Mays.
So real quickly, when they worry about it's going to be harder to do something, it would be much easier for the police to get convictions if they were allowed to beat confessions out of people. But clearly that is something we're not willing to tolerate in a free society. And so every argument has its extreme. And the police can't simply come in and say, well, it's got to be super easy for us to convict criminals, even if it means we hurt a bunch of innocent people. So what? Well, that argument just doesn't fly.
But that's basically what they're doing in parenting.
In family law, they're saying, we think we're protecting children. It doesn't matter if we destroy 20 families to protect one child. They're saying that cost is okay. And the Constitution says that cost is not okay.
And these justices actually say that. They say, okay, so it might be a little more expensive for the state to have to adjudicate a parent before they can take over the care, custody, control decisions of a child. But they said the Constitution demands that. And because it does, they are bound to the Constitution. So they say you cannot put in a procedure or a process that allows the state to say it's less expensive this way to do it, or we can protect one side or one party this way, but we have to violate due process for someone else. They said, we're sorry, that is not allowed. So now you have an additional argument when you're going through this, and that judge tells you, as I know they've done to several of you, they say, we're sorry, but we're going to wait for the child's counselor to bring us back a report. Well, you know what? They didn't even have the right to do that yet. If they didn't properly adjudicate you and determine that you were unfit, they don't even have a right to take over that care, custody, and control, do they? So you would use this to argue. And here's why I wanted to bring up Mays, is because this dissenter, because you notice we're down in the middle, so Judge Markman, who didn't agree with the opinion, wrote that this person, Mays, didn't get heard for a very similar argument that Laird, which is the father in this Sanders case, Laird got heard on it. Here's why Mays didn't get heard. Mays did not preserve the argument. The court did not address the issue in Mays because the appellant father had failed to preserve the issue in the trial court or the court of appeals. You know how many times we've told attorneys you need to preserve error? And you know you just said, Tommy, how come I didn't understand the interlocutory or this or that or the, these arguments? Well, how come the attorneys aren't understanding that you need to preserve your rights and the due process violations in order to raise them? So ask yourself that, because they're trained in this. So when you bring it up, now bring this case up and say, absolutely not, I'm not going to wait, because a lot of them say, well, let's wait and see if we lose first at this hearing. You tell them, I'm going to show you this case, and I want you to use this. So just tell them, pull arguments out of it, copy arguments from this. So I just wanted to point that out because we say that over and over and over again, and everybody's always saying, prove it, prove it, prove that I have to do it that way. That's why I'm saying this case right here proves all the arguments we've been saying. Here you go right here, constitutional parental rights. Now this is in the actual opinion that agreed the parents have constitutional rights. This is not in the dissension now. This is in the opinion that ruled. This is in the opinion that won. The 14th Amendment of the U.S. Constitution provides that no state, shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws included in the 14th Amendment's promise of due process. And they go on, and they used Washington versus Glucksberg, didn't they? So I wanted to point this out. That's a United States Supreme Court case.
And one you'll find in our book.
And Meyer versus Nebraska, same thing. United States Supreme Court case and in our book. So you'll see that they derived their argument from the U.S. Supreme Court case. This is a beautiful case that teaches you how to tie in your arguments in your state. You see here they pulled state cases that they backed these up with. That is how you do it. You don't have to put up with that delay anymore. You don't have to sit there and let them make decisions about your child in those hearings anymore. But you can't expect to argue constitutional rights in a dispositional hearing or status conference. And here's why as well. They say it in here. And that's why I tell people all the time, we don't make this stuff up. We find it in these cases, and then we tell you guys about it.
Because it makes sense.
Yeah, it is. It is, and that's why we simplify it for all of you. Okay, dispositional hearings. What is the purpose of them? The purpose of them is for the court to determine what's in the best interest of the child. So does a parent get heard on their rights? No, not in those. Why? Because the court had to make the assumption that the parent is unfit in order to make those determinations. This case says it. The court had to make that assumption. So here you are standing before the court saying, hey, I'm a fit parent, I can make these decisions. You know what they're doing? They're just skipping that step. Did they find you unfit? They'll tell you, no, we didn't. But yet they're using a process that is only used for parents that are unfit. So what would you argue? You would argue, excuse me, respectfully, Your Honor, and this is just how I would do it, okay? So we just make suggestions. Respectfully, Your Honor, but I believe this is the kind of hearing that you would only use after I've been adjudicated to be unfit. And they'll be all pissed off, of course, and say, baloney, and then you'll pull this out. Your Honor, they use United States Supreme Court cases. I understand this is from a different state, but I'm telling you, this is the way things are supposed to be done. I understand it's not how it's been done, and guess what else you have in this case? Go down to the dissension. Go down here to the bottom. I was hoping to find that dispositional thing for you real quick. This is stuff that I pull out for people taking our labs in our classes. But they actually described what a dispositional hearing does, but I pretty much covered it for you. But as soon as they say, this isn't how it's been done, you say, yeah, I understand this, because Judge Markman explained the way it's been done. But these justices have finally seen the light, you could say. They finally understood that it's our liberty interest, and a liberty interest requires higher standards of due process, which are covered by the 14th Amendment, right?
And the bottom line is they cannot deprive you of rights to your child unless they have proven you unfit or that they have proven that you are a harm to your child. And the only exception to that is in short-term, limited situations where they have probable cause to believe that you are unfit or you are a harm or danger to your child. And even in those situations, due process demands a very rapid turnaround where they have a series of hearings very quickly and they have to prove sufficient evidence to continue to hold your child, and that failure to prove that, they must let you go. It's kind of like being indicted for a crime. They can arrest you, but if they can't indict you, if the grand jury says, no, there's not enough evidence, they have to let you go. And it's the same thing in these hearings with these children.
But let me tell you what this father did in the case that we just showed you. And the father's name is Laird. They tried to do that to him. They put him in those dispositional hearings. They ordered that he had to do a service plan because CPS or DHS was trying to take his child. And they were telling him that he had to do, psych evals, drug testing, and all kinds of things because they had jurisdiction over the children because the mother had already signed paperwork that she had neglected or endangered the children because she was a drug addict.
And here's the key thing right here between these dispositional hearings and the hearing on fitness. Before they can get to those hearings where they can order you to take psych evals and do all of these things, they have to prove you unfit. If they prove you unfit, then they can determine whether they're going to take your child from you completely or make you jump through a bunch of hoops before you get your child on a limited or permanent basis.
And most states require them to jump through those hoops.
Right. So the hearings I'm talking about are the hearings where they have to prove you unfit or prove you a danger to your child before they can do anything against you. They cannot punish you. They cannot force you to jump through hoops until they prove you unfit.
Okay. Let me get back to this is what they did to Laird. I was trying to cover that. What they did with Laird is they tried to tell him he had to do these things. And most of you parents, this is what's happened to you. They said, you know what? I hear what you're saying, but that's too bad. This is the way we do it. We're allowed to require you to do a service plan and all these things that we're telling you to do. Laird said, no, you're not. You have to find me unfit. I want an adjudicative hearing. He pushed so much and so hard for that. Guess what they did? They dropped their unfitness claims because they were claiming, well, you're unfit, so we got to do all this because the mom's unfit, right? He pushed and pushed and pushed. They dropped it. And they continued to say he had to do those things. We dropped it, but you still have to do what we say because we're the Almighty. We're in charge of your best interest of the children, of your children. He said, no, you aren't. And he still pushed. And this is what I mean when I tell parents and what Ron means when he says they must have a fitness hearing. Do not be afraid of that fitness hearing if you're going into it knowing your rights. Be very afraid of it if you don't know your rights because they will take advantage of that.
The only thing that gives them authority is proving you unfit or proving you a danger. Short of that, they have no authority. They have raw power. They have the ability to intimidate you into doing these things, but they have no legitimate authority.
So they dropped it, hoping he would notice and just said, well, but if you do these things, this is going to be a lot easier and quicker, and then you can get back with your children. And most of the parents do that. That's where he didn't. He said no, and he filed the mandamus. We're assuming it was a mandamus. We haven't actually seen what he actually filed, but because it was interlocutory, there's only a couple things you can do with that to challenge a non-final order. So he filed that they were violating his due process, and he argued it on the basis of what they call a one-parent doctrine. And the reason this is important is, guess what? That one-parent doctrine is just about as broad as the best interest doctrine. So there's a couple little tweaks you need to make, but for the basics for tonight, when you read this case, think of this case as saying best interest doctrine, and you'll start to see the similarities in how you can fight this right now, tomorrow, with your courts, telling them no more status hearings, no more of these things. You didn't prove this. I want you to prove it. And then if they try to continue to pose those burdens on you, use the rest of the argument that Laird worked in here. It's already worked once. All you got to do is set yours up right now and use it as well.
So here's the deal. When it comes to the best interest of the child, the court only has authority to act in the best interest of the child in a dispositional hearing. The court can only conduct a dispositional hearing once it's proven you unfit or a danger to your child. Therefore, they do not have authority under the best interest of the child in an adjudication hearing.
Okay, so we're going to go back to the presentation. I hope that explains that a little more and tells you why we're so excited, because we knew that so many parents that come to us are so stressed out, afraid of challenging them, afraid that they're not going to know what to do next because they hit them with these ideas and they didn't know what authorities to look for. And this one was so easy and simple. So the dispositional hearings, the status conferences, those are the ways they're delaying and costing you money. And what are they using to do this to you? Best interest and parens patriae. They talk about both of those in that case. Also, I wanted to address, since we're running out of time here, what's different in divorce than in termination? Because they might say, well, that's all fine and great, but that was the father, the mother had been terminated, they were trying to terminate the father, it wasn't a divorce issue, they'll always come back at you with that. So you go and you look for authorities in that to argue, and one of them that I found was the first one that says the private interest that's affected by their action and the risk of erroneous deprivation of that interest through the procedures they're using and the probable value. This is all coming from this first quote here, if you can see it, of any additional or substitute procedural safeguards. The government's, and finally, the government's interest, including the function involved and the fiscal administrative burdens that the additional or substitute procedural requirement would entail. I know I kind of read that out of order. The reason I read that to you is because you have to argue with them that they can't lower the standard just because they're saying that they're only limiting your rights and that it's different in divorce. It's a private interest that they're affecting, and it's a liberty interest. Look at the bottom of this slide. You are defending a liberty interest. Go back to the case in Sanders. Download it from Google, from scholar.google. So unfortunately, I didn't set up the little link to help you download it tonight. Download that case and look at how they argue private interest and liberty interest. They say in that case that your children and your care, custody, control, your decision-making authority regarding your children falls under liberty interest. Remember in the past we said historically it fell under property, right? That stopped being the case. So now your children fall under liberty interest. That just raised up that standard on them. That just also raised the state's burden. They now have to prove you're unfit or clear and present danger. So that's how you get there, okay? So they're just using divorce as a vehicle to authorize their authority. The other reason they're doing it is you are very, very emotional in divorce. And when you're in that emotional state, you are very easy to take advantage of. So they know this. And what's easier even more for them is if you don't know your rights, for them to take control and tell you what to do. So the state's forgetting one of their duties. Their duty first is to defend the privacy of your family, and then to take jurisdiction of a child only after there's no parent to look over their rights and protection. They're also forgetting that that duty to protect the privacy of family means each parent and child, not the nuclear family that came from the creation of the child or during the marriage, or even if there wasn't a marriage, during the relationship. That's not where the duty to defend privacy resides. It resides with each of you individually as it resides individually with your child. So look at it this way too. They look at your child as an individual. Why are they not looking at you as an individual? They're looking at you and the other parent as a unit that they can just sweep under the rug. If they find one parent's ridiculous, they can throw both parents out if they want, right? So question that. So rights in conflict with the other parent, we've covered this in the past before, but I wanted to bring it up again because they'll throw that at you. As soon as you diffuse their argument that they can't violate due process in divorce just because it's not termination, then they'll say, well, you're not agreeing with the other parent. You both have the same rights. You do have individual rights that are the same, but they're not in conflict if they use the least restrict. Well, I take it back. They are in conflict, but the state is only authorized to use the least restrictive means, which would mean equally respecting and protecting both your privacy and liberty interests equally.
And here's an important point. When you're married, are you ever in conflict? Do you ever argue with your spouse over what's best for your child? Of course you do. Parents argue all the time. There is always conflict about the rights of the parents on who's going to decide what, on who's going to have the child at any given time, on who's going to have the responsibility to take care of the child primarily, who's going to make more money for the family. All of those things can come into conflict. None of that in a marriage allows the court to come in and deprive you of your rights. Why then can they do it if you're divorced? And the only thing that comes into play is that with a marriage, you have a natural mechanism to help resolve these disagreements because you both have, hopefully, a vested interest in maintaining the marriage and coming up with a reasonable outcome. In divorce, you don't have that marriage mechanism, so what you have to do is have a more formal process for dividing that time and those rights, and the court cannot order anything other than equal time unless, and this comes from the latest case that we just mentioned earlier, that July of this year.
Henry Sanders?
No, the McCullough, not McCullough.
The buffer zone?
McCallan, I mentioned it earlier. It just came out July of this year.
Well, you mentioned it to Tommy. We weren't in the webinar.
I'm sorry. We'll provide that case. It just came out this month actually, and it was about the First Amendment rights and the buffer zones, and they discussed the least restrictive means test, and what they said that because the state had not proven that other least restrictive means would work to solve the problem, that then their action was unconstitutional. Therefore, if the state has not proven that equal shared parenting is a solution to the best interest of the child, then they are unconstitutional in their actions.
Yeah. Here's the part that I was looking for on this slide. You may have already read through it. And this is the dispositional phase where DHS, or that's their CPS, that's their Child Protective Services, was arguing back when Laird said, "You're violating my due process." They argued the dispositional phase obviates an unadjudicated parent's right to a fitness hearing. They were basically saying that their procedure was allowed and therefore they didn't have to find whether or not he's fit or unfit because they already took jurisdiction over the child because the mother was unfit. So they tried to sweep his rights under the rug, and this court, the Supreme Court of Michigan, said, no, sorry, because this Supreme Court also overruled one of their Court of Appeals decisions. As remember, he had to go to the Supreme Court because the appellate court denied him. They agreed with DHS, the Child Protective Services. He had to go to the next step, which is the Supreme Court, who then overturned the precedents of their appellate court, and this was their explanation. And this paragraph right here is what I'm saying. Insert best interest standard and tweak it a little bit and use that argument against best interest as saying that it's unconstitutional, that it fails to recognize the constitutional protections. Look at the bottom here. Well, close to the bottom, under A, put in best interest standard fails to recognize the unique constitutional protections that must be afforded to unadjudicated parents. That means parents who have not been found unfit, irrespective of the fact that they meet the definition of whatever else they're talking about. This one here, any adult, that's the definition they use in the one-parent doctrine that they just overturned with this ruling. So that's how you use your argument to counter their idea of best interest. Let's go to the next slide. Stay away from the better parent argument because that sucks you down that funnel of opening up their ability to use bias and prejudice against you and to lower those standards and to say that you didn't preserve error, that you were asking them to make these decisions. Remember, as we always tell everyone, you can forfeit your rights, and if it appears that that's what you're doing, then the appellate court's not going to help you, not even in a mandamus. So don't forfeit your liberty. It's up to you. If you want the right to make your decisions and to be a participant in your child's life, or you don't. but you do have the right to waive it. But be careful that you're not doing that. So don't use the better parent argument. What happens when your relationship is strained now due to the delays? Unfortunately, we're out of time, so we don't have enough time to go over this anymore, so I'm going to skip through it. But if all of you want more information, I also recommend read Santosky. If you want more information on how to use more of this stuff, we teach this every single week in some classes. We have the book that we mentioned called Not in the Child's Best Interest, and I will plug these slides in with the presentation that I send out to you so that you'll have the rest of these. And this is about our classes, which you can go to our training.fixfamilycourts.com to look and see more information about them. But we teach protecting family rights, creating your blueprint, and how to overcome family court abuses of power. And I'm going to go off of this because I want to be able to answer a few questions. And like I said, we have the book, and I'll throw that up there so that you guys can click on that if you would like to get that book and learn your rights. We also have the courses, as I said, and I think I'm just going to send those out to everyone because I want to get to some of your questions here. So let me see if I can go back into this chat. Okay, so a couple questions that we have is, what if you have assault to a family that goes back to 2004? Can they use that against you to say that you are unfit? They have to hold an adjudicative hearing, and they have to meet the standards that are in those statutes, David. They can't just go ahead and decide that because you once did something, that's going to be held against you forever. There's a couple of things. When they hold an adjudicative hearing, they, like I said, they have a different process they have to follow. Don't let them lower it in the family courts. Get a real hearing of fitness. And if they can't find you unfit, I believe that the guy Laird, he had some things against him in there. And those didn't get used against him because they dropped it. They didn't hold the hearing. So it would all matter on whether they can get you convicted of that. If they don't get you convicted, then move forward. Fight for your rights for your children. What kind of thing do they look at to consider you an unfit parent? They may try to tell you different things in family court than what they actually should be using. Remember, they're going to try to keep their power. So what I would suggest, David, again, is go to the child abuse statutes. Go to the statutes that CPS or any child protective service, in Michigan it's DHS, go to the statutes that they would use to take your child from you. That should not be lowered in the family courts, but you have to fight to keep those as being used. You have to fight for that standard, okay? Someone asked, do you ask for a fitness hearing after a temporary orders is decided? Ask for it at any time. If you didn't know to ask for it now. Reframe your case. They may try to stop you. They may say, you know, we've already gone this far. That's when you have to raise, I was unaware of my rights. So there's a whole nother argument you can make about unknowingly waiving your rights. But now, if you're still in the trial court, you have time to put those in there. If you don't put them in there is when you're going to lose them. So put them in there, and if they deny you, as they did this father, because remember, a lot of people say, I did it, but they still said no. They still forced me to do these things. Well, they can't force you to say you're unfit. They can't force you to go through their service programs. That's why this father used the appellate court to challenge those temporary orders. Okay? So you'll have to do that. You'll have to decide if that's something that you're going to be able to do. Here's the parental rights book for any of you that want to read through it, because I can tell you that if you read this first, you'll get a better foundation, and you'll be able to see some of these arguments a lot faster. Is if you just go and start reading cases, which you can do too. It took us a long time to process that. It took us a long time to figure out, what does that exactly mean, or how does that work? So we helped simplify that in the book. So that's one thing that you can go to. I also have the course package here So if you want that weekly interaction and learning how to integrate those rights and use those rights, then you're going to want to look into the courses. And we do break them down into monthly payments as well, because there's a total of 28 weeks in these classes. You can choose to only take one class or two classes, but if you do all three, then you actually get a discount because we throw one of the classes in. Here's the triple package. You can click on it, check it out, send us questions. If a psych eval has been ordered, should you submit to any specific testing that could possibly be used against you in court? My feeling is, and the way I would do it, absolutely not. If they had not held an adjudicative hearing and proven me to be unfit, then they have violated your due process, and they don't have any grounds. What are they doing that for? They're looking for something to use against you. That's like a warrantless search, isn't it? I wouldn't do it. I would file, if I can't get the court to agree with my argument, as long as you've presented the argument to the court, your objections, and put it in the file, and given them first try at ruling on this argument that we're bringing up to you tonight. If they deny you that and they still want to push you to do it, then I would file with the appellate court. Now, there are a few states that do not let you challenge temporary orders. In fact, we know one of the attorneys that has a certiorari in the United States Supreme Court right now challenging the fact that that parent cannot challenge temporary orders. So if you're in one of those states, let us know. We'll connect you up with her so that you can stay in contact and get the results from that. Because it is up to the state whether or not they have a process for you to challenge those temporary orders. But obviously in Michigan, you can do it. You can do it here in Texas. Okay, someone said and yes, Justin, if you have not been proven unfit. Steve says if one is pro se, how can one use the client-attorney agreement and enter these concepts into the court? Okay, I didn't show you guys the parent-attorney agreement, so let me put that up on the screen real quick. And I know we didn't go over it, but we do go over it in the webinar that I sent to all of you earlier and confused everyone, making them think they'd missed this webinar. This is the free attorney-parent agreement. Click on that. It should download for you. So let me get back to your question. So how do you use it pro se? You would take those rights and put them into your arguments in court. You would also put them into pleadings. When I was pro se, I liked putting them into my motions and pleadings because there were times when the court would cut me off, or I was afraid I would get too nervous and not say the argument, and I wanted to make sure it was in the record, because if I ended up appealing, everything that's in the record, the appellate court can look at. So then it would be in the record and preserved. That's how you preserve error. So I always recommend that you put it in there. I know there's some attorneys that don't like to do that, but it really worries me because so many of them don't understand how to do this, and they don't, and then you didn't preserve error, and it disadvantages you tremendously. It forfeits your rights. Chrissy, I'm not sure what your question is on that. I see that you're comparing the statutes from our book to the South Carolina statute. If you're finding that the statutes are taking over your rights, your care, custody, control decisions to your children without proving you unfit and having a proper fitness hearing, that's what we're suggesting that you look into, is to hold those proper hearings before they're allowed to make those decisions. And I think that's all we're going to have time for. If I missed anyone's question, please email it to me. But I do appreciate everyone attending. Appreciate it. All of you have a great night. I hope I helped you with some of those fears, and I hope you can sleep better. If you are going to make these challenges, feel free to let us know if you need some of our one-on-one help to help you go through your argument. Again, we can't practice law for you, but we're happy to share any knowledge and information that we've learned to help you strengthen and empower and give you as much leverage as possible so that you can get your time back and your rights and your authority back with your children. So all of you have a great night. Thanks again. Bye now.